to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends, live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be, and welcome to this coverage of the hearing in the Canton Reed case. It's a mixed bag today. It could be, well, I see it going in a few different directions because what it is today is motions and evidentiary hearing. Are we gonna see Bev hear arguments, go over what both sides have to suggest or why they believe their motion should be followed? Or are we gonna do the Bev thing and say, I'll read it, I'll write it, see you later, you wasted $50,000 flying everyone in. Have a nice weekend. It's Friday. I'm going to the Cape. I have a small. We're going to have Gretchen Voss, the journalist, in there today. We're going to discuss if Mr. Greene needs a Dorbert hearing. We're going to discuss all the late evidence that came in. We're going to hear the arguments around the multiple findings in from both sides that Greene had no skill to find what he claimed he found, and the other side arguing, well, he clearly had the skills because when he did the test again and again, it was actually Trooper Garino who never found evidence that was right in front of him, which I don't believe because Trooper Garino has proven time and again he is probably the best IT cop in the world, the man who didn't notice 10,000 communications in the Sandra Birchmore case. If you catch my drift. And so tired of prosecution have many trials before the retrial, it's getting deposed on all of the defense experts on a false pretense that they are unqualified. I agree with you 100%. Bev is the queen of the castle. Bev should tell Brennan, no. The expert always makes fun of me because every time he asks me a question, I answer no. That's what Bev should be saying, because both the experts they want to have a Daubert hearing on is highly clearly qualified, as is the ARCCA guys when they're gonna try and keep them out. And it's just another way to drain the war chest of Karen Reed. I know there will be no repercussion because that's the big problem. In Denmark, had they done this when the case was over and when she is what she should be, found innocent, because every evidence that's found that you can weigh, measure, prove is Karen Reed did not hit John O'Keefe. John O'Keefe wasn't hit by a car. The rest is just, well, she was a meanie. She might have yelled at a young girl. They probably wasn't a super loving couple that was about to move in together, but that doesn't mean I'm gonna go unalive someone. In Denmark, when that was done, she would have been reimbursed the court costs. Every expense that the court puts on you, you can retrieve afterwards, because the state forced you to use those money because they put on a case that didn't stick. But in America, there's a high level of immunity for all of this, and Bev will just say, well, it was possible for the jury to find her guilty. They didn't do it, and that's well, that's a good thing for her, maybe. Oh, are we going to start kinda on time today? I don't believe it. I don't believe it. I had the case from Florida queued up because I thought, oh, maybe we're going to have a ruling on that telephone, but apparently court is kind of live. Well, I will keep it on in the background. Well, I can up the volume and I can kill your volume so you don't hear it. So it shouldn't mess up the audio too much. Gotta have that Dilbert hearing. Well, it's a Daubert, but still. Yeah, Melmac, Helen from Holland, Kim Farron, Stephen Frenner. I'd never watched Caddyshack. Hey, Jana. And Sui. One defense expert is more qualified than all the Commonwealths and Spanky combined, just saying. Yes. And that's the big problem, that they're going to bring in a dog behaviorist, which won't be allowed, according to Bev's earlier ruling, to testify, because they said only medical doctors can have an opinion on this. Karen's messages to John were mild compared to my rant. Yeah, it was a big old nothing burger. Oh, and by the way, hey everyone over on Valhalla's channel. Valhalla was up cuddling goats. No, he wasn't. He was talking to the expert. But he will join us as soon as he can get out of bed. Hopefully you don't mind hanging out with the rest of us. And any of you who doesn't already from my channel, follow the wonderful Valhalla Awaits. You should do that. You don't see any more cute goats than you can on his channel. Hey, Katie. Speaking of Judge Bev, have everyone been watching the bench trial? No, I haven't seen anything on that. I know. Oh, that's Turtle Boy. I know that. I know that Melanie Little at least covered the first day. Hey, Jinxie.
This is Tori. Pleasure to meet you. Oh, okay. Very good. Very good.
Oh, Tori is from IT. Now they cut their audio. You haven't even watched Caddyshack. I don't even know who you are anymore. Well, I'm too young to know Caddyshack. I'm not old. It's Taco Friday. Well, I don't know. Paula B, how was it? I hear that she was acting like a normal judge in that one, not like she's doing this one where she's inserting herself and clearly showing bias, but actually doing what she should be doing, ruling from the bench. So I don't know what to do with that information. You're watching Groundhog Day on Sunday. I will be sleeping. Caddyshack is hilarious. Don't know it.
Morning. How are you? Hope you had a good trip, eh?
You should probably kill the audio when two lawyers are talking.
Oh, did you? I would have. I wouldn't have given them to you, but for the fact that you gave them to me last night.
Tax abuse? I was reading old motions from the Commonwealth in this case, and they reference AJ's previous cases where he motioned for access to a witness phone and how it is a pattern of behavior or whatever. Then Bev cited.
I know you were. Of course we were.
I don't know.
Well, thank you.
I don't know what that is. Oh, then Bev cited those cases in her decision, so Bev doesn't like AJ, as if it's not obvious. I don't know if Bev can cite cases AJ normally have, because AJ is a lawyer in California, and as far as I understand it, every state has
a couple of transcripts. And
have different rules, because every state has their own Supreme Court, and you can have different rulings. In some states, you don't need to have a Cellbrite certification. You can just say, "Well, I use it on the regular," and then you will be found an expert. AJ was slimy because he always asked for the victim's phone, and Bev agreed with this Commonwealth. He had previous cases in. Oh, thank you. So it wasn't Massachusetts, because it should be.
Welcome.
Yeah.
Enter your meeting.
I think they should. And this is how many months have we been doing these kind of? It's 2 years now. I think we started February 2 years ago. They should know to mute their microphones.
You have joined the meeting as an attendee.
Hey, Julie, thanks for 6 months. Hey, Kirk.
What are you laughing about?
The Penny Bench trial reminds of the insulin case we just watched. The wife is accused of the red rum of her husband, who had a heart attack after an argument. That's why I didn't want to jump on it, because I said, how the F can you find him? You agitate a man enough so he gets a heart attack. You should have known that, and that's a murder. It's not like she sent him out for a run. They were having a fight. Yeah, it's and they should be allowed to if it's directly linked to the case. And I think that in this case you should be allowed to look at least a couple. Look at Brian Higgins' phone, Jen McCabe's phone, Kerry Roberts' phone, and Brian Albert's phone. Those phones should be looked into. I think all of that is direct.
thank you for clarification. I don't know why you couldn't get documented. Motion for clarification.
Hey, Dawn. They need to put Lally on the stand. They can't. He asked Greene at trial if he had received Whiffin's email complicit in witness tampering Griffin did the edit, which didn't come out until after the trial. They can't put Lally on the stand for that. He's a lawyer. He has a wide discretion to do whatever he wants in court. And I'm not a lawyer. I can't tell you. I know that some people think it's highly improper, and other people say, no, they were just asking a question. So I don't know. And let me do something that I normally do, and which is why I am the little Peter the pilot fish, not one of the big sharks. I'll caution you, whatever you read on Twitter isn't real. All the people who will tell you this is clearly, wait till a lawyer talks about it. And maybe even wait till two different lawyers, not lawyers on the same stream, but two different lawyers. Because there's a big difference how you see cases and how you interpret the law. And there's a big difference if you might be practicing in Oklahoma or Tennessee contra if you are in Massachusetts. So how bad it is, I have no idea. I'm just saying, as I'm always saying, this case won't be thrown out. The feds won't come Monday. And she better prepare the best defense in the world, because they will pull no punches, sadly, from the Commonwealth. I still hope it'll get thrown out, but I don't believe it. Hey, Chante. Hello, Jessica Thomas. Everyone who attended the home that night should have been a potential suspect, and all phones should have been immediately seized. Well, that's a little... That's overreach, in my opinion, because there's no direct link between Brian Jr. and this case. It'll be hard to see how you could prove anything. I really like he touches the mic. So we also have to remember, just because we don't like the people in this case, they are afforded the same rights as everyone else who is close to a criminal case. I would not risk a bench trial with Bev, though. What I heard, and you watched it, but what I heard, she's acting like a normal judge. Apparently, they can, as a witness, according to Betterow, who is an attorney. Yeah, and is it lawyer you know has the opposite? Again, I don't know. I don't want to say up or down. I'm just saying Bev will be the queen who will decide. And until appeals, nothing works. Yeah, I know Betterow talked about it. You don't have to yell. I'm talking, so I'm not as fast. The Daubert hearing, the Gretchen Voss, and I think the motions filed. Zach, you're on the wrong server. I saw Betterow said Lally needs to be on the stand. I'm sure they could find a way. I don't know how. I've never seen it before, but a lawyer can make themselves a witness in a case. We saw that in the case with the guy who shot the immigration lawyer and went on the wrong.
Laptop and all that, and no cell phone use whatsoever today.
Because they inserted themselves in the case by going around, but that was the defense. I don't know how it is. No, you missed nothing. Send dreaming. Yeah, I know Betterow said it, but I'm saying I don't know if he's right or because again, other people say the opposite thing, and both the people I've heard talk about it is in agreement that the Commonwealth didn't have a case. So I'm not throwing one of them out there. It's the same. I asked Andrea Burkhardt about, is it Brady violation? She said, nah, you can argue it, and Bev will say, no, it's fine.
Yeah, so that one.
Thank you.
Well, he's suing people because apparently they got to his 33 herbs and spices. I hereby condemn this woman to eternal guilt. Thank you, Brandon. I am a man, but I will probably have eternal guilt. I think because Lally and the inverted Sallyport video, but yeah, there's a lot of things that I thought, and I think we talked about it when it went. Said how can they be running this case when they clearly are misrepresenting evidence? But again, Bev is the queen, and if she says I'll allow it, she'll allow it. Then you can go on appeal, but appeals are for losers, so you'll have to lose your case before you can appeal it. Would you rather try and win your case instead of going through an appeal process where you don't know anything and you will be found guilty before you go there? Thank you, Reby. It's a gift from Jemima. Brandon is going to get us all involved in llama drama. He'll try. Punishable by... Thank you, Brandon, for demonetizing my channel again. Well, you didn't do it the last time. That was the Sinclair group. Hear ye, hear ye. Have you hit the like button yet? Thank you, Jemima. It's Friday. Bev will be tired, so no doubt she will be complete and another bitch. No, I'm thinking she'll just say, I've read your motions. I will consider it. Have a nice Friday, and she'll be out of there. I could see this being a very, I don't know, did they agree to argue the motions, or is it just a motions hearing? Because I can't remember. I had planned going back and watching what she said the last time. But as I gathered, there wasn't any talk about arguing motions. It was just a motions hearing. And she can do what she's done in other motions hearings. We are out in 15 minutes. This court officer looks like she could be the older sister of Turtle Boy's ex-string Lindsay. And what's a llama? It's kind of like an alpaca. Hey, Krista. He should get shaved. I am a wuss. Is that what's her name? Esty? I think isn't she on Twitter as Esty? The woman in the black clothes. And that's Daddy Karen. Or BFF. I'm not sure. Because you said someone should get rocks thrown at them. That's encouraging violence, and you know I don't do that. That's Jamie's job. Yeah, it's yeah. She's a hoot. A hoot is a sound an owl makes. Oh, yeah, Sarah Boone has made a complaint that her appellant lawyer haven't contacted her yet. It's just a boilerplate. It's machine written. It's not even a 45-page letter. My honey is getting a little low energy. But she just asked when her appellant lawyer is going to talk to her. And the judge responds that, what did the judge respond? He said, no filings or something. Come on now. Move faster. The judge just asked, in response to your correspondence, the following applied. Attorney Joshua Adams has been appointed to represent you for an appeal. However, at this time, no notice of appeal is on file. So she has an appeal lawyer, but he hasn't filed for an appeal.
Have another transcript on the way up. Laura's bringing, and then there are. Do we attach both reports to the motion?
I didn't notice
We have
that.
2 reports attached to the motion. Should I give you separate copies for exhibits?
Yeah, imagine how demasculated you are that you have to sit next to a guy that they paid extra to get in because. But isn't the rumor that no one wanted to retry the case, and they had to get a hired gun to do it? You can only hope.
The folks that just showed up, please, no cell phone use whatsoever, even during sidebars and breaks. Don't want to see cell phone out at all. No cell phones.
Is that the grand rule because he filmed Aiden's trial? Did you also? Yeah, I'm hoping so much that the anonymous letter is from Plevin, and yeah, they just accidentally keep finding more evidence. Turtle Boy was in the media area before. He's not now. Swear jar fun because Brennan's voice. Stop being a hater.
This is a very famous scene. Over here, that story. The judge came out one time at any shooting.
No, Lally isn't late. He's out just fuming through a carton of cancer sticks. We aren't allowed to bring our cell phones into the courtroom. I have above the doors in our court, there's a window. I have twice seen people tape us with mobile phones over there. That's kind of weird. Yeah, yeah, that's the juror box. Why won't you read my super chats on member chats? I'll read your member chats, but I won't read that you encourage people to hurl theological fragments at people as a punishment, because I'm pretty sure I'm not allowed to do that on YouTube.
Who's better than you?
Well, at least not in my geographical location. But
You're a gentleman.
oh, but I'll still read your member chat as soon as you send it.
Okay, got it.
Will the Gossip Girls be on their phone, on the smartwatch again, talking? Doink haven't been there to any of the hearings. I think he has a court order against this case. Doesn't Meredith have a RO on him? Yeah, or his crotch shot. Yeah, gotta sit still for a couple of hours. So, is he bald or somehow? Lally or Paul O'Keefe? Yeah, I really don't like that he's allowed to do that. I know that they are allowed in there as family and the Marcy rule and all of that, but he shouldn't be allowed to intimidate a lady who hasn't been found guilty, and that is clearly an intimidation tactic.
I'm good.
He looks miserable.
Does anybody check to make sure
John's
the mics
father.
are not on at our table? with the TV.
It is. It is.
Remind your folks about cell phones, please. Make sure that on the silent mode, please, all cell phones, please.
That boss?
It's under the table.
Yeah, that's a BS move that the camera is or the mic is on the defense table. The Fall River reporter Mukado lady has an arrow against him. I think he doesn't go because she sometimes goes and covers this case. Yeah, she was the one he pushed outside. I was harassed. I was assaulted. Excuse me. I miss Doink. We had the murder case. I had the brother of the victim. He was kind of a doofball. He put on Facebook the day before, let's go to court and make him pay no matter what. Really stupid idea to say. So you will get police to look a little bit at you. This shouldn't be allowed. I'm sorry. I know I'm stealing your feed, but they should be reprimanded for putting the audio on for the defense table. They are discussing tactics right now. You try and see it from his side. He's hurt, angry, wants vengeance, as any brother would, and is convinced that she did it. Not defending, declaring. No. He can be all the angry. He can be fuming. Then put him in the back of the room behind her. There's no reason he's allowed to sit directly in front of her. This is another thing that, and Bev should rule this courtroom. She should say, nope. And I hate they have this where in our courtrooms, the audience is always behind you. No matter if it's family or what it is. They will always be behind you. Because again, that's another thing where we are different, and why I don't like the family impact statement is this is emotional pressure that you don't need. You need the law. You need the law. You don't need a guy with a DUI staring down a woman who saved his behind from prison. Happy 12.7 subscriber day. Maybe read chats. Brendan, I read all of your chats except 50% of one of them. It's like arguing with Jamie. And hopefully, am I back down under 12.8? The most difficult thing to do is to convince someone they have been lied to. Deep down, they know, but accepting it is. Yeah, I agree with you on that one. Will Baker get mad enough to end the stream? Only time will tell. I'll just leave. That's not John's father. Isn't he an uncle? The one that looked like he was falling over in the trial and his father never wears blue hoodies. Isn't it the dad? Is it an uncle? Well, he looks really bad. Iris, no. Yeah, and again, I don't care that that he's angry and he's staring at her, but he can get this spot. There's no reason why he should be sitting right next to her, mean-mugging her the entire trial. No Miss Little today. Doesn't seem like it, or she's running late. Yeah. I don't know if it's some weird custom in Massachusetts. He got a right to be there and sit side by side. Yes, he does, but I don't think they should be allowed that right. Because I don't think he should be thrown out. I just don't think that he should be allowed to sit there and mean mug a defendant in a case, because she is not found guilty. She is innocent until proven guilty. And this is just emotional stress and she is running her defense. She should be in a state where she can react to what's going on in the case. No Miss Little, only MLS Little, who is stoned. See, the context matters. What's the over-under on Valhalla will show up? That depends on how long we're going today. I don't know how many beers did he have last night. No, he seemed fine when I talked to him. 7 hours ago. Thank you for joining, Ian. Oh, you didn't see them come in because Tom was fertilizing the bushes. Oh, yeah, Tom is sick. And it still goes there. Valhalla went to bed 2 hours ago. What it was. So you haven't been to bed either. Jeepers creepers. He didn't unalive a person. He slammed into an elderly person who I think he has severe injuries and is still recovering from it. But yes, she paid his bail. I would never do that. Brendan is a good guy. I don't know why people have such a bad view of Brendan. You just have to pre-read Brendan's text sometimes. Yeah, I don't know why it's such a badly run courtroom. Chris Albert is the one who has the D&E pizza, right? And then it's the other one who... Oh, no, Chris Albert is also the one who drove into someone, went into hiding, and had a clean breathalyzer when he came in. Was it 30 hours later? Bev taking her sweet time. It's a controlling tactic. Can they move to have the judge stricken? No. Well, they can, but she will be the one who will decide it. I bet you she will argue no. So you can't do anything. But that's because you told me to never read your chats, Zach. So you asked me, and I will never do it. Never have I done it. And just because it's a new year, it's not a new me. Never reading any of Zach's chats. Thank you, Zach. Yeah, he's a select man or whatever they call it in that town. Oh, hear ye man is coming. I really wish it would never have requested to leave the other courtroom. Yeah, but I just hate this courtroom setup. The lawyers behind each other, audience on the side, and the press here, and the jury box must be up here. So, well, it's here, but I think that's Aiden. But it's just really, really bad because then you have the witness up here, and now the feed froze. That's the totally wrong time to freeze, please. And now we're back. Didn't Paul paralyze someone with his own DUI? I can't remember. I just know that guy got banged up pretty good.
You wonder what. But actually, we just did one yesterday when the attorney was. You were catching people, right? Larry catching this off the back? I noticed just because it moved, it might change.
This is a pre-trial hearing. No jurors are in a pre-trial hearing. It's just all the,
We may not be there.
what do you call, bookkeeping before the trial.
Copy of Ian and Jessica's report that we admitted as
Yes, he seems a little lazy.
Just in case.
The jury will be seated right here, but there's no jury in a pre-trial hearing. The trial isn't on till this, April 1st, which I think is appropriate because there's no bigger joke than this going to trial again. Are they taking testimony from Greene or just arguing for him to stay as witness? They are not. I know a lot of other YouTubers read the docket wrong, so they thought it was the Daubert hearing today, but they will be arguing if they should have a Daubert hearing with Greene. That's was no time as a profanity. Oh, I like a profanity. So no, Greene won't be there today. I had to leave the big courtroom because half the jury box is behind the witness. Juries should be able to see the faces, so that's why Pep moved it. Yes. But why do you have a courtroom like that? That's so stupid. Talking about so stupid, Jamie isn't. Hey, Jamester.
Morning.
How are you this fine morning?
I'm good. It's Friday.
You sound like a hoot and a half today.
I am.
Did you get caffeinated?
I did. I need more though.
Yeah.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, Uniform County of Norfolk. You are near, give your attendance, and you shall be heard.
Yeah, but he's the good guy.
Massachusetts, who is now
Is
open.
that Kerry Roberts?
everybody.
I'm really
Judge
bad at faces, so I
22-117
don't know.
Powell versus Karen Reed. Can I
I
have
think it is.
Why is it so spotty now? Of course, just as the start. Let's try and refresh it.
Mr. Jackson.
Good morning, Your Honor. Robert Alessi on
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie.
Do you know your...
Okay, let's see. So we've got several matters
No, that was
for
too
this
blunt.
morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCCA. And the last one is the Commonwealth's motion to exclude witness Richard Greene's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider.
I'm sorry. I know that the Commonwealth wrote that, but she shouldn't say the debunked opinion. I don't like that. That, again, to me, just shows bias. I know it says that on the paper, but first of all, debunked isn't a legal term.
Regarding the notes. And I do want to say that I received this morning
I noticed that too, Julie.
a motion to file an amicus memo.
Is it an amicus?
The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Bertie.
She is a journalist who talked to Karen Reed, who have some private notes that that state wants in because they would use it against her, because whatever chicken scratching she made during an interview is 100% evidence. First of all, it's her opinion about what Karen Reed said. Second of all, it's protected under the free press. They don't have to give up their sources. So I don't like it.
Good morning, Your Honor. Rob Birchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit
Sure.
the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes, and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has
You are unmuted.
particular reason to delve into them. So the question before the court is
What
whether
did
the
you do?
Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendants. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade. And among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with the source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts,
91% persuasion and a little meat bet.
facts, is it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it's a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, oh, that was a case like this one, where that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out of the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no
This is the defense lawyer for Gretchen Voss.
distinction between the on-the-record and off-the-record interviews when it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings. It did not treat this confidentiality promise as a factor in the equation. That we submitted was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, notice it says materials, not source identities, courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So, what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection.
Nick is allowed in
in
here.
advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there's uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information.
Is everyone a little drunk today? Marissa, Jinxie? I don't know what's going on with you today.
As to the balancing test in the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information has extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. In LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number three was the resulting disincentive to keep outtakes, or in our case, keep notes. And number four, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The fourth estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out is that in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight.
So she's afraid because of
Now,
the evil turtle
the court
riders.
mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time.
But you in no way can link to this case. This is BS. Is that her? Don't eat rooms.
Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Birch. In the amicus brief or the memo that was filed this morning. I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over.
Then every communications relating to any of your police officers, the motions you denied, should also be allowed in. You are such a double, two-faced. I was about to use Brandon words here.
Well, you know what, though? If the Commonwealth had a rock solid case, they wouldn't need to go fishing for all this stuff. This is what's just really irritating to me.
Yeah, and again, she's sitting here saying, well, the Commonwealth has proven that we need all of this. No, because you ruled that they couldn't go look in her parents' notes, but a journalist she had a sit-down interview with, just so they can say, well, her lawyers instructed her not to answer that question. Oh, no, you didn't answer that question either because Alan Jackson told you not to. That's what they want to do. They want to put that in there. But again, are they going to call the journalist to the stand? And does she have the balls that real journalists have and say, I will not testify. I'll go to prison to protect the freedom of the press? No, she won't. But then we'll get all the funny communications, because now we need to know who from the Commonwealth side have talked to this journalist, or any agents working on behalf of the Paul O'Keefe family. Because we know Kate Peters publicly stated that she's a spokesperson for the O'Keefe family. Can we get in there that Miss Voss apparently did shrooms, or allegedly did shrooms, with the spokesperson of the O'Keefe family? That should be allowed in also then. Floor, door, chaw, swore, more, war. No, she doesn't have that kind of integrity. Bev said no DNA proves no dog bite, ignoring a scientist's testimony about DNA being destroyed by water and mold. Yes, she's an idiot. Well, she had to do that or she would go to prison. Yeah, and Bev is not the finder of facts. So, Wall, I'm saying Wall. Do you need more letters? YouTube will get mad if I type whore. Yeah, Brandon.
So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant observations, things of that nature.
Well, Ronna, there's nothing in the interview notes that is reflected in the story except architectural details, that there was a rosary on the bureau and the wall was blue or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case.
No.
She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a report for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay.
Limitation,
All right.
not
So I'll take this
limitations.
under advisement. Thank you.
Under advisement.
All right.
This is a two-edged sword for Gretchen Voss. Allegedly, she is close to at least some parties on the Commonwealth side. But she's also a journalist, and a journalist should be able to offer off-the-record comments to a person they have an interview with. So she will try to defend that, because if she is now forced to give up all her notes in this case, who is going to talk to her the next time off the record? No one. Her job as an investigative journalist will then be done. And she can't live high on a hog anymore.
So paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a Chewy letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the Chewy letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing that for the defendant?
Because the one judge who has to rule if Bev is crooked is Bev. If they want to go back and show her bias, they can do it in an appeal. The judge gets to decide.
Good morning, Your Honor.
Morning.
I agree with Mr. Kennedy's recitation of our conversation. Just wanted to please the court. We did get that letter. I was copied on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail. And
It must have been a TUI letter from the feds, yes, because both sides need to analyze it.
utilize that letter in my response to the Rule 14 argument. So if we could have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was
So
thinking.
we'll do this next
Tuesday
week
and Friday.
and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that. So I will take the lead from the two of you on that.
Thank you.
Okay. All right, so this brings us to the Commonwealth's motion to exclude defense witness Richard Greene's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit.
Because the Commonwealth doesn't believe that they have the necessary expertise to do what they do, and they have hired an expert with the exact same degree they have.
Attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Greene, and then another affidavit from Mr. Greene that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
May it please the court, we filed a motion to exclude Mr. Greene as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Greene should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. This case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available.
Ms. Hyde, who changed her opinion after her first report, stating, yes, it did happen, then changed it to, no, it didn't happen.
Later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Greene and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Greene, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Greene has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits.
Proctor had multiple wrong times in his, and the Commonwealth argued, well, that was just, he just wrote it down wrong. And now you're the arbiter of how people should write affidavits. And again, he is an expert witness. It's for the jury to decide.
Affidavits are changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Greene's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Greene's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, and insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Greene prior to trial, stand behind these statements under oath. Would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common view in the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factual.
What? You're gonna rely on Whiffen, a guy who says the program that he works for isn't reliable without his very special, personally, I don't know what you will call his program, but a free download version you need to know to use Cellbrite, who didn't even test it on the right model. I hate this case.
Sound and then go knock down glass houses. That is not the approach the government is going to take to this case. Mr. Greene is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Greene looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data.
The guy is testifying in hundreds of cases a year in exactly this. I know Bev is probably going to try and keep him out, but that this man who would have hired this exact same expert in his case is standing there arguing it with a straight face. I'm getting mad. Think I can safely day drink on under this name? Yeah, you should be able to do that.
In this case, Mr. Greene in his affidavit proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Greene has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology,
Thank you, Jessica,
and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search, 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Greene then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Greene's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs and then has a last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be opened, it is open at a particular time. And if that tab is reused, the original time will imprint. And so certainly Mr. Greene knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report. And yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast
He loves that word.
between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 227. The only effort that appears in this affidavit by Mr. Greene is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen. And
have you seen, because was the report given to the defense at the time? And do they have to provide the report with an affidavit? And thank you, Jessica Thomas, so much for a laughing fox super sticker. Super sticker. But yeah, this guy will die by the word methodology.
But a simple understanding. Wall file can contain information as a repository. And the description or misunderstanding by Mr. Greene of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. He's looked at this phone that there were 2. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance. Leaving somewhere, somehow. Not an uncommon.
Come on now.
The police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty.
So-called expert, again.
He's such a D-bag.
His circumvitade is longer than yours. You are most famous for losing a case. please refrain from throwing dirt at a man who probably could run circles around you. I just hope that Alessi or LSC or whatever his name is better at explaining technical things than AJ and Janetti was, because they didn't really argue this part really well. I hope he really comes prepared and just slaps the Jesus out of this guy. I really dislike him. Bad dog. Teach me to realize the quacks on Canton again. Yes, I want you to release the quacks on Canton again.
To say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehash that manipulation with the PDF being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number one are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Greene. It is suggesting that a witness with no other evidence whatsoever was involved.
You start using
in a
that on
conspiracy
records.
to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts.
Come on.
Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact and data and science. Mr. Greene does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police.
No.
When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Greene ignores. And so not being able to prove user manipulation because it didn't happen, he turns to police manipulation. And he says that there can be a problem where the hashes don't match. But the problem is the hashes do, they match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then...
I believe I saw you over there. That's before I started streaming.
Somehow it
It's
must
an
be
oldie
because
but a
there's
goodie.
manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, grade key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. The problem most expert witnesses went through that process. No manipulation. But Mr. Greene doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Greene's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Greene's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is...
He has a wide range he can go before he gets sued.
Appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Greene. Well, the reason why is Mr. Greene does not provide it.
Oh my God.
So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffen's report directly contradict the assertions, the unsupported assertions of Mr. Greene. There is no testing that his opinions have been subjected to. There is no peer review. There is no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Greene's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known potential rate of error. Well, if we see and read Ms. Hyde, and it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Greene didn't do. Their own report that they offer in support undermines the idea that Mr. Greene did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not.
Yes, this is why it's BS, because first, the opinion of an expert is to be evaluated by the jury. The evidence is what the evidence is. The only thing he can say is he isn't, based on his lack of education, skill, and knowledge, qualified as an expert. And Bev can say, I'll allow it. Or she can say, have you seen his CV? He's more qualified in data forensic than you have at your bar exam. So please shut up, stop wasting my time. Which she should say, but she'll say, we'll have the hearing. And why isn't Whiffen there? You're going to let Miss Hyde, the lady who changed her report, come in and say, well, he can't prove it. It's an affidavit. It's not a report. You'll get the report before the trial starts. It's kind of their way. They can hide it a little bit before you start, just like you do when you drop reports right before the trial starts or during the trial, like happened in the first trial. I don't like this guy. If it's not clear enough for you, I really despise this guy. I think he is worse than Lally. He is slimy. And I know that I am the first to tell people, don't hate defense lawyers because they are just doing their job. This is the face on a defense lawyer. Everyone sits and thinks, oh, they're probably bad guys. He's doing this for $75K.
Not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, positions of Mr. Greene are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Greene is really just a vessel or an attempted vessel for the defense, third-party culprit defense. It is not lost on me. I'm not unmindful of,
because it'll change the timeline.
Being search how long Diane Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time.
But then let's talk about another little thing. If it happened at the time where Jen McCabe said Karen told her to do it, she lied when she said we were sitting in the backseat of the squad car, because they didn't. We have camera showing it didn't happen. Second of all, that time that's apparently, according to Whiffen, your expert, rock solid evidence, it happened exactly at that time, is when Lank arrives at the scene and talks to Karen Reed. So if you're, I really can't speak when I get this mad. Okay, it's time to get drunk and have a Friday.
About Mr. O'Keefe and how long he could survive the vote. Under the extraordinary broadness of circumstances, in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Mr. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence.
No, it's the forensic evidence is wrong then, because we know for a fact she wasn't in a car where Karen Reed said, I have blood on my hands. That's weird because I am not on my period, which is such a weird statement that Jen McCabe made. She's not in the car at that time. Right after this is when she sneaks up to the house where the light turns on before she enters the house, but no one was awake inside. Go F yourself with a cacti.
Greene is going to be a witness in front of the jury in light of the fact that he has no methodology and he's wrong on the science. In addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense. He should have to stand behind those claims under oath. And so I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Lessing?
Yeah, I'll sue everyone for this. They're going to kill me. Sir, I'm going to need you to calm down. Sir. No. 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 Exactly.
May it please the court.
It may.
Mr. Greene is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Greene, and I want to cover the baseline for this hearing first. Mr. Greene testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
who the hell have their cell phone turned on in court? Idiots, you were told before court started to turn off your phones. How's long to drink 10 beers? That is the question. Well, we have to come to Dollywood and find out.
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Greene has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Greene's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Greene is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Greene does not articulate a methodology. That is incredible to me because the opposition and Mr. Greene's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor.
Oh, and by the way, for anyone who is wondering, did he provide the evidence? Yes, he did give them their the methodology, and he knows this is, I can't say bullcrap this early, but he did provide his methodology. Either Hank the Tank is dumb, which he's not, or he's lying, which I hope he's not.
While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their two reports, neither of them even describe Mr. Greene's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Greene's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint, that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Greene has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Greene did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is
Come on.
and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffen's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking.
What the hell is going on?
Here's the key point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Garino processed it. do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Greene had to ask for the data. Then what happens, misstep number 2, Trooper Guarino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Greene had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Greene that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Greene justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Guarino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Dean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5, and 1 through 4 is usually all one needs to do as a data forensic examiner, but Mr. Greene went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Greene state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could.
Yeah, I'm quiet because I'm just channeling.
Please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
Was that a small dig at her not looking at the things is provided?
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Greene and Ms. Hyde match up with the tools used and how insufficient Mr. Whiffen and Mr. Guarino are. So if you look at the left-hand column on Mr. Greene, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Greene. You see 6 tools used by Ms. Hyde in May of 2023. many of her tools, exact same as Mr. Greene. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Guarino, Trooper Guarino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Greene had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Greene did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Greene makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert-Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr.
3 green pies down, bring in the rest. 7 to go.
Greene's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Greene's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Greene says it means what it says. The search occurred at that time. Now the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it. It's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact and that Mr. Greene doesn't have any fact. Well, Mr. Greene's got a lot of facts, and he also, of course, has an opinion. So what we have from these 2 demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Greene put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Greene's doesn't have a methodology They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Greene has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Greene's experience next to Mr. Whiffen, Mr. Greene testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Greene lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Greene in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Greene, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lally. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things to do when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I'm not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Greene's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Greene used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to.
Oh, that's
yeah.
I'm happy to look at the report if that's what you're referencing.
I'm
Where
going
do
to
I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way.
That's not good.
If Your Honor is at the transcript, I'll go to the transcript right now. This is.
Really thought I had some fireball in my golf bag, but that's a negative to this is going to come to a screeching halt eventually. Fireball, are you a 16-year-old college student and a female?
The June 14th transcript, Your Honor, of Jessica Hyde?
Yes.
Thank you. So we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffen's report that is now before you, Mr. Whiffen only used in his analysis now, Celebrite.
Welcome, Valhalla awaits.
Hey, buddy, how you doing?
I was mad, angry, yelling, and then Mr. Alessi took the stand and started yelling for me. So now I'm happy again.
Sorry,
Sadly,
I'm late.
can you DoorDash some liquor to Brandon because he's talking about getting Fireball?
Ooh, don't do that.
Yeah,
Don't
bros
do
don't
that.
let bros drink Fireball.
Yeah,
No.
that's not good. That sounds like a bad idea, Brandon.
Yeah, but I have a suspicion Brandon is a 16-year-old college student and
Probably.
female.
That checks out.
Hi,
That
Valhalla.
checks out. Hi, Jamie. How you doing, babe?
I'm good.
Mrs. Valhalla has been trying to wake me up since like 8:30. It hasn't gone well.
Well, this will put a little pep in your step, and I can take my bio break now. Now you're here to entertain the troops.
Physical analyzer and ARCCA, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring, in its 2024 December reports, all the other tools. Even though those tools show this timestamp of 22740 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to 1 physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it, that Mr. Greene went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Greene says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you used that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQ Lite. Those are 4 of the tools that Mr. Greene used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications. So they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite, to Axiom, to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools?
Because the Commonwealth is ill-prepared, underprepared, and Brennan is... Let me just get this right. out of the way. 5 pies. Come on, Val. You look like a train
This
wreck.
guy is great, by the way. I
Yeah.
like him.
As I just X'd at Turtle Boy said, he's strong on technical stuff. A really weak point in the first case because they couldn't get their point across. Is Cellbrite open source? No, Cellbrite is a forensic tool you buy. 95% of Cellbrite's business goes to governments, police and courts. I'm going to be a conspiracy theorist. I know I claimed no drama would be allowed on this Grift stream today, but I get a feeling that he's just a placeholder so they can toss it at some point. He seems like if I can't get the experts out, if I can't get all the evidence thrown out, what the hell can I do? It's not like they seem like they have a case. They keep finding other evidence, and I just have that nagging feeling. And maybe I should try and get better Rowan and talk to him about it, because to me it just feels like he's gonna run her war chest down, and then they're gonna drop the charges, or just go with the OUI.
They are too
really bad.
Determined to.
I'm amazed that it's gotten this far. Right when they got the mistrial, I was dead set that this wouldn't see another trial. They would dismiss it before it got to trial again, because I think this case has been such an embarrassment to the Commonwealth.
Yeah.
That being said, this has gotten much further than I expected it would. Any chance I can get a TLDR for the last 2 hours?
Yes. Brandon, I don't own a basement, and I think neither does Valhalla, so it must be Jamie. No. And then have yourself a day. Come on, buddy. Cheer up.
Oh, I do, but there's no door in the basement. No one can get locked down there.
These $2 chats are not only pissing you off, but some banker somewhere is throwing a fit. I bet you is. Marissa is really mean today. Brandon got to her.
Oh, dang. Dang. Marissa. Calm your tits. What's that about? Coming at me all crazy. I get it. I'm a little late. You don't have to be upset.
They filed. They had the this lady is
yeah, I did.
This lady is Voss, the reporter who didn't want to turn over her notes. Bev said, well, we can retract some of it. I'll take it under consideration. Then Brennan got up and lied his ass off about, and again, he wanted to keep evidence out. He wanted to keep opinions out. That's not what a Lanigan hearing is for. It's to battle, are you an expert? And, Mr. Whiffen couldn't be there that day, but we can do it next week when they have 2 days scheduled. And then he just lied about him having no methodology, didn't provide the evidence of anything. And there are 4 pages where he goes through his methodology. He is lying constantly, and he have done that at every single hearing. And then Alessi came up and said, Your Honor, what that guy just said is BS. That's the TLDR.
Okay, that'll work.
So, he said methodology 40 times. That's his favorite word.
Yeah. Well, the biggest problem is he's claiming that's not even the art. That's not even what is in like dispute. Like for him it is, but like nobody was arguing Greene's methodology, saying it was wrong. That was the whole thing. So he's just going on and on about it. Like no one said it was wrong. Not even your expert said it was wrong.
No, and it's just BS, because it's not for the court to decide if his opinions is correct. That's for the jury to decide. And he is more qualified than Whiffen, who only did Cellbrite's normal standard police education. This guy is constantly updating his stuff.
Hey, Bad Dog. thought it was pretty fun. That's good. That's good.
But no, but I really like they got this guy on board because they were weak on the technical stuff in the first case. But he's really good at it.
All right, I have one more very important question. Who is sitting next to Karen Reed's dad over there? Who is that?
She is called Esty. She she's doing standouts and dances and stuff like that for Karen Reed.
I like her.
Yeah,
I'm a fan.
I'm going to tell Miss Valhalla.
I think she's watching.
Oh, so if we see a stabulator come flying through the air,
I thought she was about to stab me when I didn't get out of bed for the third time. She tried to wake me up. It started getting a little rough, y'all. I feel threatened. I feel
Esty, not Etsy. Sorry,
I'm in danger.
Rules and analysis. And her answer is strikingly the same as Mr. Greene in his affidavit in our opposition. Her answer, the Sanderson's tool, which Mr. Greene and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Greene was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's an opinion issue.
I think she has a lot of makeup on also today, and I'm not close to her, so not just when she's up close.
In that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. Yeah, there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Greene, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Celebrite Physical Analyzer, and it's gone, the search is gone, right? And we know why it's gone, because Celebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Celebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Celebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AM ET timestamp, the determination in prior analyses and from Celebrate is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses and Celebrate physical analyzer.
So you're telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Greene's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Greene did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Greene did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Greene to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Greene did. So there's great criticism of Mr. Greene from doing what is proper for a digital forensic person. And it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Greene say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Greene pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die Nicole.
Yikes.
There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Greene say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly.
Yeah, this is the biggest misconception about Whiffen, that he actually punches in data. He is a sales rep. That's what he's doing. He just have a fancy title.
The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Greene points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Greene wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Greene simply points out is that doesn't make any sense either. That is the essence of Mr. Greene's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Greene, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
So I have both.
Brandon, you want
The
5
second
pies,
one
but,
on the body of it does
5 pies
not
makes
say
us
it's a
celebrate-
supplemental
celebrate,
or
cry.
anything. If it was in the cover letter, that's what they're both
Celebrates.
docketed, so they'll both remain
I was just going to
docketed.
say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other.
Brandon has
So, Your Honor,
58 minutes left to get the last.
in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Greene relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Greene makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state.
Defense.
But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYEDES. That didn't have it. So Mr. Greene did what any good digital forensic person would do. He called up support and said, well, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Greene's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Greene did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Greene qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing where one party challenges the witness of the other and then says, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who.
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all?
Why does she always have to do that?
What the methodology?
Because it's the defense.
So, Your Honor, in conclusion, I would.
Yeah, she doesn't do it to the state, Jamie.
To deny the
but it's
motion
annoying.
of the Commonwealth.
I wouldn't say
to
never.
Mr. Greene on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
Oh, I can't wait for that. Everyone has the will to win. Few has the will to prepare to win. Is Brandon going philosophy on us?
I think he's
I
just
know,
quoting
Haley.
Rocky Balboa.
It's not
I know
about
she's
how hard you
snarky.
get knocked down. It's about if you can get up. Let's hear Brendan come up there and say everything he's just said is bullshit and
This guy's got a lot of good points, though. Like, when was the last time you've ever heard of Celebrite being like, oh, I know it says 2 o'clock, but that doesn't really prove he was in the bar while it was being robbed at 2 o'clock. Like, that's never
People
happened.
are convicted every day of Celebrate information.
Every day. 99% of convictions that we see are because of the phone data from Celebrite.
But
And
this
all of a
one
sudden,
is
it's just
wrong.
not reliable. Yeah. Oh, it was 6 hours early somehow. Get the fuck out
But it's funny because they're just disputing this specific phone data, but they're using all the phone data elsewhere to say, oh, see, look, he wasn't here. He wasn't here. No one's here. So it's like
you can
can't have it both
trust
ways.
Apple Health, but you can't trust Celebrite.
What did he say? This is the one deleted piece of Celebrite info out of 4,050 something, 56, something like that.
There is one search that has been actively deleted out of 2,456 or something, and that is "How's Long to Die in the Cold." That is
how
too unlikely that it could only happen. Bobby Knight, that's 6, you bundle of sticks.
A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cache items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple. It can be explained. It's science. It's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger.
You're
That's why
such an
that's left to
idiot.
Experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool. You can use 30 tools.
Methodology
Well,
has
say,
been mentioned, you
on the time
idiot.
spent,
Bev,
how long to die in the cold.
come on now.
Occurred at
Stop
227
it.
on that browser. That is the time that was open. That window was opened at 227. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 227 starts counting after 6 a.m. in the morning. And so that's what Mr. Greene doesn't do. He doesn't engage in methodology at all. He doesn't agree with methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's in addition to her 2023 report. Mr. Greene has not written the report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Greene. There isn't. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit in the theory. The government offers bring in Jessica Hyde next week or English another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Greene promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Greene has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been launched.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but
We're going to have
for the
it.
Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So
She's such a fraud. Because
She is like, that is not the argument. They are arguing in the opinion. I'm sorry. I didn't mean to yell over you. I was mad.
Get him, Jamie. Get her.
It's the opinion you're pissed off about. Sorry, but geez, it's not his methodology.
No, and his methodology is the exact same as Jessica Hyde. The only one who didn't use that methodology was Ian Whiffen. Can you give Valhalla a pep talk?
I'm Valhalla.
No, can you give Brandon a pep talk? And no.
I was
Sorry.
I give myself a pep talk every morning. Mrs. Valhalla says I'm weird, but I still do it.
Do you really?
No.
Let's hear it.
No, stop it. Ugh. It was a joke, Jamie. Jesus.
I wish you would though.
Brandon is.
Why is that?
He needs 4 more in 48 minutes.
4 more what?
Shots.
Oh.
He promised
you got
10
this,
before,
buddy.
before noon.
10 before noon? All right. All right.
So he needs a little pep.
I
believe in you, Brandon.
You need to man up. Don't be a little bish. Start drinking.
7. Be excellent today. Time for a pregnant pause.
There you go.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
He was so bad.
we'll keep next week and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or in the process being turned over. There was one further report. We've retained Dr. Wolf.
Why does he sound like that?
I'm waiting for his report. He's away.
Because I'm
So my
split him up.
expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure that the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. It's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right,
The
so
analysis is done.
He's going to send it over on his
The
Xbox.
actual reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I did not review it. And I think that accounts for. We've been through the entire amount of discovery that was prior. It has all been base numbers. It hadn't been before. It's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers and provided everything that I come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This one to protect the board this morning to the defense, so they have anything that, from my perspective, my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the Attorney's Office, and that continues, and I have another production as well. So we call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want about the defendant's case, and I've provided that again on the scope of that.
All right.
And so we do not have an official discovery order.
Gigabytes.
Defense to have the discovery meet 30 days after I complete mine.
It doesn't take that long to download.
No. Not
I
even
also
close.
filed, but I did not see on the docket, or we sent in.
I need Sean to tell me to put the fries in the bag. I
Close
don't
the
know.
deal, Brandon. Close the deal.
Yeah, come on now, Brandon. We're rooting for you. Everyone put one in the chat for Brandon to hit. 3 more shots.
Not file a motion for clarification. Your Honor did not mention that as an important notice that we had sent in because I am greatly respecting the first trial date and there was work to be done. So I would like to address that motion to clarify what appropriate report.
Okay. All right. I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right.
He needs to be out of here by 12. He's
That's
into
great.
the fifth and
So the
having
Commonwealth
five
expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just. In this motion, there's a footnote that references. So this motion from the Commonwealth was filed from the defendant was filed on January 23rd. So more than a week ago. In the motion, I believe, there's a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And Ms. Hyde has a report regarding a phone. That's all that's really left to discovery. So that's all I can say.
All right. So if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
we've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not, the court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we can get it done by Friday. We are working on it. We're not,
so
there's no strategy for us waiting, I promise you.
Be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. Time to respond.
Understood.
So we need to come up with a scheduling, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation?
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, protocol in terms of getting our expert out there.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
Okay, so
probably a little bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information. for such egregious conduct.
Sure, okay, I'll submit this, that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Come on now.
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there's actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything in Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to
I'm sorry,
dismiss.
the motion is dismissed on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates.
Monday, 8
because we're
p.m.
going to
is
need
in
to schedule a
Denmark.
hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time.
If this is an agreed trial,
All right, so the Commonwealth will have all of its
as
discovery to
Lima-
you, it expects, by Wednesday, the 5th.
That's correct.
Okay.
We're gonna have Marissa come in and do some.
We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file your motion to dismiss.
Yeah, I don't know how she can do that.
And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week. We're also going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can
All
safely
right,
say yes.
so February 21st, and I'll put this in writing, filing of all evidentiary motions that can be an out-of-court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Karen looks mad.
Your Honor, that is that week of school vacation week.
Yeah.
Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right, yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend.
I
I know you haven't seen it, so it's hard to figure out how much time you need.
Interesting.
Is the Commonwealth available on the 18th?
I'm available anytime.
Yeah,
We'll
because
put all
you're
our
paid
efforts
by
in. If we
the.
have a problem, we can let the court know.
Okay.
We'll do our best.
Government.
Okay. All right.
Brandon says AJ sporting a touch of
Okay, so the 14th will be an
bi-coastal
out-of-court filing date.
style in the hair.
The 11th, an out-of-court filing date.
I think these beers are starting to kick in.
I think
So
so.
the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st,
Of,
and that will be an out-of-court date.
of February or March.
February.
We will do the hearing on all evidentiary motions March 4th and or 5th.
Oh, I'll wait.
I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get ready for trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
You want to do those filed by the 7th?
We can do March 7th. I need to be in Copenhagen. Well, Hella will be streaming on March 7th.
Me and Marissa got
On
it.
the 18th, which only gives me 2 weeks to decide them.
Bev needs a big wine order for
Because
another
we're
long
starting the
trial.
trial on April 1st.
Half
Jury
days,
Commissioner's
twice
Office
a
has been
week,
fantastic
so she
about
can
getting
get
us
hammered.
as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later.
Why is she incapable of making a decision?
Anything else we need to
on
discuss
the
today?
spot?
Not on behalf of the suite, thank you.
because
No,
she
thank
wants
you.
to do it in
All right.
writing
Thank
and
you.
have someone help her with it, is my belief.
That makes sense, right? Like she knows what she's going to do already. None of these
Yeah.
decisions are a surprise.
I actually think after the slap down that
You are muted. Goodbye.
Alessi gave, she's not gonna give them the Daubert hearing on the witness.
Do you have a hat that says grifter on it? Is that what your
I have
hat
two.
says? That's outstanding.
This is my birthday gift from Jemima.
Nice.
So I'm trying to force her to go into the business of making merch for smaller streamers.
I like it. I like it.
She made the. What the hell?
We need a better option than Teespring. I'll tell you that.
Yeah, and I don't know what stamps cost in the US, but she made the stickers.
Oh, that's cool.
And sent me a ton of them, so I can chuck them in when people win
Nice.
something or do a giveaway. And
Look at you, Jedi Jess.
she's that's and she can print on stuff maybe, but
Somebody's got a Cricut at home, huh?
But I was I have the minimum amount on my stickers on Teespring, and they're still like $7 before shipping. So find that's a little bit excessive. 8, market 8, dude. Well, you a little bit of a rush, buddy. You have 2 more.
What are you doing, man? Pick up the pace. Amateur hour over here.
Yeah. Well, Hella would have spilled more on the floor by now.
Right? Oh.
I have a silhouette and then a heat press and a sublime printer. I don't know. It's 10:30 a.m. No, it's 11:30.
It's 11:30 here.
Then he meant 8 on a par 3. It could be what he's doing. Yeah, he was in his golf bag earlier. But what did we learn in school today? We learned that
I was hoping you were going to tell me.
Hank Brennan has absolutely no. I can't say that. It feels like Hank Brennan will do whatever.
The Commonwealth will do whatever.
Yeah.
I mean, Lally's his boss, right?
No, because he's a special prosecutor brought in because no one else wanted to retry it. So they had to go out and get a hitman. And that's the thing where I'm and he kind of shows his moral in he's lying. He is actively lying about what's going on and what the evidence provided by the defense says. And he has done this for multiple occasions, and I really don't like it. I feel like he's a douche canoe. I'm working on it. You can fill the air for 30 minutes. Yeah, well.
Is there anything that surprises you by that, though? This isn't new, right? The last hearing, he lied through his teeth, too. And maybe it was because he just didn't know, but I feel like he should at this point.
I have a a suspicion, he still doesn't know what happened in the first trial. Either he didn't watch it, or he just relied on Lally to
Lally's-
bring him up to speed. So yeah, don't give him the rate, because then you can't charge more. Everyone will say, "Oh, it cost 50 cents." A printer that puts thoughts into your head. That could be cool. But
Sounds
I really
terrifying.
felt like today was, it's just so disingenuous. Oh, well, he didn't put in his methodology. Well, he did. And I love that someone is coming at Andrew Burkhardt on X, because she was watching it. She's stuck in an airport. And he came at her and said, "You lawyers should understand what it's about, because there's high standards to this." No, there's not. The only standard to be an expert is, do you have qualifications to have an opinion as an expert? And then the jury should say, we believe him or we don't believe him. If you're a doctor, you can talk about doctor stuff. You can say, well, we want a Daubert hearing. Oh, you're a doctor, you went to med school. Coolio, see you later.
It's not the Daubert hearings, right? The ability to allow an expert in as an expert witness has nothing to do with if they're right or not. Like homie was saying, literally every pair of expert witnesses are up there arguing different points of the same situation. That's not new. That's how court trials have gone forever. It's up to the jury. The jury decides who's more valid in their argument, not the judge, not the state.
And no, I'm not coming on Andrea Burkhardt. She might have an update stream later if her plane takes off on the. I think she's going to go into the Brian Koberger stuff. Don't know anything about it, but I would love to talk to Andy again. He's real cool.
Oh, Andrea's awesome. She's awesome.
So, but I just feel this is. I still have that, and I asked Mark back when we had him on right after they decided to charge her again. Do you think this will go away? And I still have that feeling that some night it'll just. But I know we're getting too close, and they haven't dropped it yet. But we're going to interview another witness. Is that a witness who's going to talk about how Karen Reed stole a pack of gum when she was in 5th grade, just to try and get my bad accent? It's horrendous that they have to do it with a judge that's so biased, because any other judge would have kicked this out of court. There's no way that she can just pass on what science says.
My bad. Mark Betterow has been saying since the mistrial that this is going to keep going, right? He describes them as what's he call them? Zombie lawyers. They just keep coming. They just keep coming. They just keep chugging along. Whether it's stupid or intelligent is irrelevant. They just keep coming.
But at what point can you open your twit every single day, and you open the newspapers? Judge Janine was looking at this case now. Well, she got most of it wrong, as I didn't see her program, but that's what I could kind of gather, that she was wrong about most of the facts in it. But still, I'm an idiot in Denmark talking about this case. This is a worldwide case, and you're getting hammered. Someone was saying, well, it's all the grifter lawyers who think she's innocent. Tell me one lawyer who would stake their reputation, other than prosecutors in for the Commonwealth and Hank Brennan, Mr. 75K, who says she's clearly guilty. Lawyer, I think, is the guy who was straddling the fence the longest time and saying, well, we have to see the evidence, and we have to, and he's fully on board. Emily D. Baker, who is famous for being very pro prosecution and is very hard to dissuade that maybe the defense have an opinion. She looked at it in 5 minutes and started yelling. This is about the worst case I've ever seen.
It's always telling, I think, when everybody on LawTube agrees on a case, right? And take that for what it is. But when every single person is like, this is a little messed up, there's probably something wrong with the case. There's probably something wrong with the prosecution.
Yeah. And she said, I wouldn't have done that. I wouldn't have filed this case. And that was the first case. And we know how weak their case is.
After the first one, there's no way I would have retried this. This has been such a giant embarrassment for the Commonwealth. It's got how many cops, state troopers now have been disciplined because of
I think 5?
It's insane. It's absolutely insane.
Yeah. And I'm still wondering why didn't Bukaki get in trouble by using federal equipment in his off time? I think that's a big no-no.
Well, I don't think the disciplinary hearings are done for officers yet.
No, and you're going to rely on your lead investigator, Trooper Proctor, a man that you are about to fire. He will probably be fired by the time the case comes around.
I wonder what's happening with that. Higgins openly admitted, right, to being drunk in a squad car on the stand, or was that different testimony? I guess he didn't admit to it, but
no, that was he just forgot his gun in a squad car.
That's right. It was Bukaki's squad car, right? Higgins left his gun somewhere.
No, it wasn't Higgins. It was Albert's brother.
Whatever. They're all intermingled and incestuous. They're all drunk and driving in squad cars and losing guns and forgetting badges and framing poor women named Karen Reed.
Yeah, and it's
what's going on here?
Jedi just said she needed a zombie lawyer.
Outstanding.
So I made a zombie lawyer.
I like it. It's like a Funko Pop.
Yeah.
That's awesome.
AI is great for people who don't have any skills. I'm covering the other trial. I'm going to cover it again at 1 a.m. We're going to catch up. Yesterday, it was so boring because they don't show the evidence, so we can just hear audio. And we were watching a video for an hour when nothing happened. And I was drawing cockroaches and ninja ants.
Yeah, I was there. I remember.
Oh, yeah. Brendan, thank you so much for gifting a membership to Twabble. You still need 2 more, Brendan.
You can do it.
Yeah. Get going. We believe in you, man.
Just shotgun one. You got that.
Yeah, shotgun him. I'm going to need a surveillance approach to land.
Okay.
1 more.
You got this, bro.
Get to it so I can get some dinner before I have to stream again.
You got this.
We trust you, man. Oh, it's going to come back up if you shotgun it. Well, don't do that. Tom already puked outside of court today, so don't do that.
Did he really?
Yeah, he's sick as a dog and still went to court. Do you think they are like poker now and pot committed because Karen could sue the heck out of them all afterwards? She can't sue the heck out of any of them.
Prosecutorial immunity, right?
Yeah.
Basically.
High proof beer. Lally's free, Bev is free, Brennan is free. Could you possibly sue the Canton PD? It's America. You can sue everyone.
She might get away with being able to sue Canton and maybe the Massachusetts State Police if she can prove that they, did some shadiness. But you got to keep in mind, y'all, the judge that's overseeing the case and all the surrounding prosecutors and stuff, they're not going to agree with that statement. So she's got a long way to go if she's going to pull that move off.
Don't apply to civil rights violations. What civil rights violations have she incurred? They were investigating the case and they just couldn't prove it, so they had to let it go. Happens every day. It's not a civil rights violation. The best thing she probably could was sue Proctor for invasion of privacy because he looked into her phones before he had the search warrant, and he didn't have, and he shared it with people who weren't hired by the PD, so there was no reason for it. I think that's the easy thing. It's really, really hard to sue the police.
Don't get me wrong. She can sue them, right? She can file a lawsuit. It's just
she can sue, but there's a very big difference in the Baldwin case because they willfully withhold evidence, and we have no evidence so far that we can 100% say they lied to the defense, because all of it is happy mistakes. And if they come up with something, Bev will just say, well, it was an accident. So I don't know. Quirk of a case law leaves it safe to railroad an innocent person, then lose fairly after committing prosecutorial. Yeah, but again, that's not like the system is built for the little man. It's built for lawyers and police officers. So that's the big problem. How about malicious prosecution? Is that a thing?
You got to prove intent, though. Like that's the hard part. It was
her. Everything pointed to her. In the end, they just had to drop it because they didn't think a jury would see it the same way as her.
You would almost need like a video of somebody going on a rant talking about how they know it's not her and they're doing it anyway to get a legitimate malicious prosecution case going.
Yeah.
Like the standard is so high.
And yes, you could sue and get a settlement. We see that a lot with police because they don't want all of it. Because again, if she sues them and she gets the go, she can get into to a civil litigation is really fun because there's way more you can do in looking for evidence. She would probably get access to all the phones they can't do in a criminal case.
That would be interesting.
All
the discovery. You're
sharing discovery that, could be really interesting. But I'm still
Discord, right?
I just don't, because I've seen this, especially during the trial. Oh, she's going to win Canton. Oh, I'm showing what I'm doing on the screen. Yeah.
I tried to tell you that twice.
I don't listen. I'm like Jamie. Nothing is free. Life is on the line. Free lawyer. Count me out. I've had innocent projects peep. Charge me like 10,000 for a civil forfeiture. Do you? I'll just smile and wave. No, Edward Scott, I'm not saying that it's Bev's choice if it goes to a federal judge, but you have to prove that they willfully and malicious withhold evidence that could be exonerating. And Bev, if it comes on, will just say, well, this wasn't exonerating. It was a happy accident. She allowed them to show a video that was docked and didn't do anything about it.
Not only didn't do anything about it, after it was discovered and addressed, just let it slide. Like, yeah. I see how that's not the real video. I see how that's manipulated and edited, but that's okay. No big deal.
Yeah.
We're going to let it slide.
I'll allow it. Now get to writing while I contemplate this beer. Well, Brandon, like every woman I've been with says, you're fast.
That's not a compliment, buddy. It's not a compliment.
Oh, I thought that was a compliment because they ghosted me right after. Why didn't they file a motion to substitute the judge? They did in the first case, but the one who will make the decision if they need a new judge is the judge they want to remove.
Yeah.
Which is also a stupid rule. That should be. I've actually been in a case where the defendant wanted to throw out the prosecutor and the judge because they had just found him guilty in something else the week before, and the judge said, "I believe I'm capable of being unbiased, and the prosecutor is just doing his job. His job is to get you in prison, so it's not biased that he wants to get you in prison." Yeah, but you were mean to me. Yeah, we then gave him like nothing. And then he came up and said, "Oh, I'm sorry."
Minor details.
Yeah, well, he didn't get that much time in prison. I think he got like 14 days where he possibly could have had 3 months. So they didn't prove all the facts. But everyone, it's 5:45. No,
it's not. It's
it's 11:45. I have to transmulate the time. I will go make myself some dinner, and then I'll come back. What is that painting behind you? Oh, Valhalla.
Me and Diva did a painting the other day. Let's go. I don't know if you're aware of this, buddy, but I paint on stream occasionally. The last painting that I did with Diva is this one. It was a little winter wonderland painting, if you will.
In a winter wonderland.
It's fun. We've got another one coming up, Let's Go, on next Saturday, the 8th, I think. It's on the 8th. I think it's a Saturday.
Yes, that's the 8th.
It just looks too good. Well, thanks. I did it myself.
I
think Lesko's clearly drunk. So
yeah,
my painting looks good.
Okay, I'll tank this beer with the goats, but the goats aren't on stream. My man's facial expression while Addy Alessi schools the court that it's not a hashtag value wins the internet today. It's hash value, and it's very important. Yeah, I love that he went up there and said, well, just getting a few technical words isn't the right thing. You need, and yeah, it's not a hashtag. I don't know what a hashtag is.
Eddie looks so pleased. He's like, yeah. I'm glad we brought this guy in. I like this guy.
No,
that's
no
true.
By numbers.
That's true. It was a blank canvas when it started.
But everyone, I will be jumping on that Colin Griffith, and his mom was Kathy Griffith. Really,
bizarre.
Really weird. And I'll do it as soon as I've set it to 1 o'clock, but I'll jump on it as soon as I have gotten some food in my belly. As an artist, this painting is well done, just like his steak.
Thank you. Thank you.
I saw Cody. He showed a steak the other day. He could just have been eating boot leather.
I saw that. That he was like cooked to perfection or something. It looked like it was charcoal briquettes.
Yeah.
Like it was not an appetite. Listen, Cody, buddy, you don't. That's too well done. That's like extra overdone. That was not good. Not good.
He's from
Cody.
Alabama,
Not
right?
Good. Somewhere in, I think so. Mississippi, Alabama, Louisiana. It's something like that.
Come on, Brandon. I've been dragging this for you. It's like drinking with Valhalla.
Easy now. Tonight, of course, is Friday for us in the States and Baker as well.
It's Friday tonight in Denmark.
FNL. Yeah, we'll be on FNL tonight. We'll go over on the Experts channel and horse around for a little while. Come join us over there.
And tomorrow, I'll steal the White Rabbit and have her on my channel.
That's right. She's coming on Stabby Day tomorrow. That's outstanding.
So she will be free at last, free at last. Oh my God, free at last. Because the expert won't be there to pull her chains.
Y'all, the White Rabbit is one of my favorite people on this planet. I hope you guys realize that. She's amazing.
She can look at you in a way so you regret what you just said.
She's amazing, y'all. I'm excited. I'm glad you finally brought up the pluck to invite her on the stream.
No, it's just because she normally goes to bed at around midnight, so I don't want to get her out of bed early. Mr. Whole last part. No, Bev doesn't make any decisions.
No, she never does. She always puts it off until she can have one of her lackeys write it out for her so she doesn't sound like an idiot. That's my assumption anyway.
I'm Jimmy. How y'all doing? Yes.
When did you first meet Marty?
This is in the summer of 14.
And the most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Honey, I'm taking you to Paris and I'm going to get you a Louis Vuitton bag for God only knows how many thousands of dollars because we have somebody else's money to live high on a hog, right? He's not.
To live high on a hog. I love this guy. I love that guy.
For God only knows how many thousands of dollars because we have somebody else's money.
Stop. High on a hog.
High on the hog.
Everyone has a great hash value afternoon.
That's awesome.
We are just... Well, it's his Friday, and if he's going to the golf course, he can slam it as long as he has a designated driver.
Careful.
I don't know. He's probably going to end up sleeping in a bush. He's just happy that he's not playing golf in Florida where an alligator would come and eat him if he's sleeping on the course.
Yeah, I've seen some big alligators on those golf courses.
Yeah. Did you see that one where they had a cobra? And that was a big cobra. Came slithering out of the woods on a golf course. I think it was in India somewhere.
A whole lot of nope.
That was a gator you kind of can see when it's on the green, but and it was ready to go. Jeepers.
No,
See you later,
hard pass.
devices more. Hey, Pokemon.
Hey, Pokemon.
Sleeping in the bush, sleeping in the grass. Hey, I don't judge. If it's comfortable, go for it, Brandon. Yeah. Just sleep it off before your wife finds out.
Sometimes you need a nap.
And that's it. I'm just waiting for him to say, I'm done. So I can be done. Bam, 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 bam.
Lesko's.
And now. No, this is a one-off made by the wonderful Jemima. So I don't have that hat in my store. Maybe I can talk her into making a business, getting a lot of trouble with the IRS, so I don't have to have a spring store. Done. Not worth it. Well, to me it was, Brandon, because you've been, again, way too generous. So, of course, the afternoon stream will be sponsored by Brandon for Supermod of 2025. Valhalla clearly stole 2024.
How
stealing.
dare you? Lies and slander.
Oh. Brandon, you go play golf. The rest of us, hey, Lefty. I wish I could, but he doesn't answer my DMs.
He blocked you like months and months and months ago.
What's the profit margin on a $2 super chat after overhead of YouTube and a post-it note? Well, it's YouTube takes 60 cents. A post-it doesn't cost that much. So I got a $1.40 left, and then I have to pay 42% taxes. 42% taxes, that's
It's like 90 cents.
Roughly. That's like 56, 60 cents. So I'm making 80 cents on $2.
That's pretty close.
So that's
Pretty close.
But I don't deserve any of it, and Brandon is way too kind. So is all the rest of you who did contribute to this stream. Please join me again in about an hour-ish, maybe half. Follow me on Discord or on Twitch. I'll put up when I go live and cover the Colin Griffith trial. I think there's a granddad testifying or something today. There's an old guy with a big mustache. So we're going to cover that. Mr. Valhalla, if I get up there tomorrow, see you over on The Experts. Or
And you know what? I'm not going to be upset if you sleep in a little bit. I personally believe that everybody should have the right to sleep in a little bit when it's needed, and no hard feelings. No hard feelings.
If you're 2 hours late to a stream, it's just fine. You are always welcome to be late on my streams. I'll entertain the same way. The rest of you, have fun. If you're not coming back, enjoy the weekend. See you later.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.